And now you have an NEC whose decisions will never be subject to public scrutiny, criticism, challenge, and also justiciable in a court of law. It's getting very, very scary for me. Yesterday, they made the parliament less transparent. Now, today, they make the NEC less and less transparent. Two actions in 2 days.
What had happened, I think, yesterday was very opportunistic of the government, using the condolence occasion for Julius, which I think most of the members of parliament turned up to show their respects. They realized they had the numbers and it was difficult for their members to leave. So they brought both motions to the floor.
In tribute to Sir Julius Chan, as one of the founding fathers and the person who participated in developing this constitution, and that's how we continue to honor the legacy of the founding fathers, Sir Michael Somare. And if they had any sense, they would have consulted with Sir John Momis, like the Honourable Governor said, who's still alive. But this government doesn't have any sense. This government's not concerned about the people.
So it was certainly concerning and disrespectful for the government to actually use the opportunity on speeches being given in recognition of the service of the late Sir Julius Chan to move a vote on the proposed law.
On behalf of the opposition, myself, the other honourable leaders that are present today, flanking me is the Honourable Bryan Kramar, member for Nomane, former Prime Minister Peter O'Neill, senior statesman the Honourable Kerenga, Governor for Eastern Highlands, the Honourable Simon Sear, and to my right, the Honourable Governor for East Pacific, the Honourable Allan, the Honourable Sepuka Temu, member for Abau, the Honourable James Donald, member for North Fly, the Honourable Johnson Wapunai, and the Honourable Ricky Morris. Members of the opposition have gathered here today to just basically announce to the nation on what transpired yesterday. You would have seen that the government moved the proposed amendment to Section 145 of the Constitution, which is the provision that deals specifically with votes of no confidence in the Prime Minister. And then in a vote of 81 to 4 and against, they were able to pass this amendment on the floor of Parliament, which basically gives the Prime Minister 18 months grace period after an unsuccessful vote of no confidence. So this is what transpired yesterday, and also with the same numbers, they were also able to pass the amendment to the Constitution stating that Papua New Guinea is now a Christian country. So these are the two critical amendments announced by the Good Attorney General, the Honourable Pulanini, yesterday. Okay, just to be clear and then provide some background, is the opposition has already filed a Supreme Court application that is currently on foot and on the validity of the Private Businesses Committee's decision preventing the vote of no confidence on the 27th of November 2024. So the Supreme Court, the substantive hearing will occur tomorrow on the 14th of March 2025, where they will then decide whether it's to recall Parliament for a vote of no confidence or to declare that the Parliament was right in its actions. So basically, we anticipate in the opposition that there will be a recall of Parliament. And when the opposition, through the Section 18 application, applied for an interim injunctive order to stop Parliament from dealing with this proposed amendment to make it into law, the five-man bench of the Supreme Court ruled that it couldn't interfere with parliamentary proceedings. Notwithstanding the changes to Section 145 and making it into law, they said this would have no prejudice on the application because the proposed law would then have a prospective operation on the vote of no confidence motion. That means that it can only come into play what the government under this Prime Minister, the Honourable James Marape, did yesterday, can only come into play after the next vote of no confidence. So if there's another vote of no confidence, and this Prime Minister successfully defeats that vote of no confidence, then this changed amendment to Section 145 comes in, and he will have 18 months protection before you can move another vote of no confidence. And by that time, it won't be relevant anymore, because we'll be 12 months before the issue of writs for the next election. So we will have the Honourable James Marape as the Prime Minister for the country going into the 2027 national general elections. Notwithstanding that change to the Section 145, we're also announcing now that we will be taking this matter to court, and we'll be filing next week to oppose these changes as being oppressive and not in the spirit of the Constitution, by restricting members and prohibiting them from exercising their rights under their mandate to move a vote of no confidence in the Prime Minister, and in that holding the executive government accountable and ensuring that we have an opposition in the whole process of Parliament and parliamentary debate. So this is what we'll be doing next week, and we expect that the Supreme Court will invalidate the changes that took place yesterday, and then we will revert the Constitution and preserve it. So that's just to make an announcement of what happened yesterday, and I'll allow the Honourable Governor Allan, who was also there, to give us some more details about what transpired. Thank you, Governor.
Fellow leaders, members of the media, I think it's also important that we go back a little bit further in understanding the events prior to these two motions being made. And I feel personally that I think it was very disrespectful in the memory of Sir Julius, because as these two amendments were moved previously, there was some opposition. And you'll find that with government, when it comes to constitutional amendments, the members in government caucus, if they want to object, they basically don't turn up to give them nothing. What had happened, I think, yesterday was very opportunistic of the government, using the condolence occasion for Sir Julius, which I think most of the members of parliament turned up to show their respects. They realized they had the numbers and it was difficult for their members to leave. So they brought both motions to the floor. In fact, if you go back to your footage, you'll find that it was a last-minute decision. You could see the Prime Minister signaling to the leader of government business, Mr. Siamalili, to bring both motions forward. Now, the net effect is that, and this is the thing, I find it really hypocritical that a lot of the members of parliament, particularly in government, spoke very nicely about the founding fathers, and they forget that the founding fathers wrote this book, basically adopting them. And on the same day, 1 minute after praising the wisdom of the founding fathers, they then found that their wisdom wasn't sufficient, and they decided to amend it. Not once, but twice, within a space of about 10 minutes. And that's probably some kind of record in the entire world where a constitution is amended twice in the space of 10 minutes. So I think I felt I had to say that, because the other thing is that Sir Julius was a member of the opposition. If he was here, he would have opposed the changes. And so I thought it was very hypocritical for them to say one thing in his memory, and then their actions are then totally contrary. I thought that was really disrespectful. But moving on, just to affirm what the opposition deputy leader has said, the fact of the matter is that these constitutional changes are intended just to support one. And I want the Christians out there to understand it. The amendment to the Constitution for Christianity is actually, in my view, it contravenes Section 35 of the Constitution. The people that wrote this Constitution, and the father of the Constitution is still alive today, Dr. John. And I think the media should actually interview this great man, get his thoughts on it, what they were thinking when they wrote the Constitution. Why did they do what they did? I think that what we've done yesterday was totally disrespectful of all the founding fathers. The Constitution should only be amended when absolutely necessary. And the other thing is that we shouldn't make it very easy to amend the Constitution like the way we are doing it. This is really easy. You'll find that, and if you go and you check with members of government, you'll find that they're getting ready to pay them DSIP and PSIP funds now in this parliament. And I feel that that's an inducement, force them to come pick up the money and then to go. And in support of all of these faulty legislations, faulty amendments, it's wrong. And therefore we need to stand up for it. I think that's the key message. And you've got your loyal opposition here. We intend to stand up for it. So, again, in memory and out of respect for our founding fathers, we need to stand up for it. The Constitution is actually meant to protect the people from politicians. Now you find politicians are amending the Constitution to suit themselves, working against the people. And the people of Papua New Guinea need to understand this. Constitution is only writing or protecting Jupla. No kind of passing by Mitla or Glowogin now. That's what it's there for. Constitutions around the world are meant to protect the people, not members of parliament. The amendment to Section 145 is to protect one man, the Prime Minister. It essentially eliminates, this amendment eliminates all of your potential votes of no confidence, notwithstanding you have the Private Business Committee, which was put in place to prevent votes of no confidence in the first place. And on top of all of that, so now you only have one opportunity, essentially, when you think about it, in every term of parliament for a vote of no confidence. The right to dissent, the right to disagree with the government was essentially removed yesterday. So now, what it means is that members of parliament are becoming powerless to change a government. To change a government, the people have to do it on the streets. That's basically what that means yesterday. And it's something that if you remember when we stood outside in the front of the house and said, Julius himself, he said it, and you can go back and dig up your archives. He said this, he is afraid that the people will change the government themselves from the street. And so that's what that amendment, the net effect of that amendment will do. It will force changes of government out in the street, not on that level. Very good. And that is essentially what the Constitution was trying to do when the founding fathers were to. And I think as members of the opposition, we have a duty to take it to the court and to put it in front of our Supreme Court. And I believe our Supreme Court will rule in favor of the Constitution. You may bagrabi mogada something. You may sawe finish you ask call him name of a member of parliament. The public will say, I'm corrupt. The man will steal, the man will make injustice. Basically, name of the and then we are the same people that decide to protect themselves. It's self-interest and it's wrong. So I think the judges will welcome us taking this to them for an interpretation. And I think we need to do it because so making them know another man more than absolutely. And the question needs to be answered and it needs to be settled once and for all. And that's why we're doing it. We're not doing it now for our self-interest. We are doing it to protect the rights of future leaders who might come. Because here's the problem. Initially, if you remember amendment of Section 145, increase already 3 years. Initially, it was 6 years protection law, 6 months, sorry, protection law Prime Minister. That was increased to 18 months. When nobody challenged it, it's like 18 months here, now we have come up lawyer. Nobody challenged it. So that 18 months has now become a permanent change in the Constitution. None of us can challenge it anymore because nobody did. We ran out of time to challenge. Now, this amendment is supposed to be challenging. Basically, as the Deputy Opposition Leader says, it only gives the opportunity for one vote of no confidence. So we have to challenge it. If we don't, it becomes a permanent fixture. Just like the 18 months change has now become permanent because nobody challenges. So I just want the people to understand why we are challenging and the dangers that we face if we don't challenge. And also the issue on the Christian bill. The Constitution under Section 45 guarantees the freedom of religion, your choice. The change yesterday pushes us towards a fundamentalist Christian state. Now, we all know the problems we have with fundamental churches of any kind, whether they be Muslim or Christian, or it doesn't matter. And so we need to protect ourselves, all of us, from this kind of religious extremism. And therefore, we have to challenge that amendment. Every Papua New Guinean, and even people who choose to become citizens of Papua New Guinea, must have the right of freedom of worship, to like the Lord. We cannot use a constitution to force everyone into one religion. Other countries have done that, and we can see the damage that has been done to those sorts of countries. We can't go down the same path.
To add, sorry, to the comments of the deputy opposition leader, also the governor, the governor rightfully said that yesterday's parliament session was permitted to give the opportunity of members to say speech to acknowledge the leadership and term of the late Secretary Chan. And they decided, Prime Minister decided at the very late hour, close to 5 o'clock after 4 p.m., without notice to the Parliament, without notice to the opposition, to move the last vote and third reading of the proposed law to amend Section 145, restricting votes of no confidence against the Prime Minister following an unsuccessful motion. Opposition weren't afforded the opportunity to be there in full numbers and to debate the last week. And they, after tabling the final vote, then moved to shut down debate and vote to go straight to the vote. But just to add to the comments by the governor for Pacific regarding Sir Julius Chan, actually there is a record of Sir Julius Chan's comments concerning extension of grace period that was actually captured in the Supreme Court reference in 2015. It says there where the late Honour Justice Kramar noted the comments by Sir Julius Chan, which was quite opposed to any increase at all because he says the following paragraphs in his affidavit. Contrary to the popular view that an extension of a grace period will provide political stability, the said extension of the grace period has served to entrench the position of the government of the day. It does not necessarily guarantee good management. It leaves open the question of inefficient, corrupt government remains untouchable for a specified period of the grace period. This was the actual comments by the late Sir Julius Chan. So it was certainly concerning and disrespectful for the government to actually use the opportunity on speeches being given in recognition of the service of the late Sir Julius Chan to move a vote on the proposed law. The law itself is clearly unconstitutional. There's 3 or 4 sufficient case law in the Supreme Court in 2010 concerning the OLIPAC provisions that restrict rights and privileges of members, to move a motion, to vote on a motion, to debate on a motion. In 2015, there was another Supreme Court decision, again upholding the same principles, in ruling a 30-month grace period. Any extension of the grace period was unconstitutional. And here we have the Prime Minister going back, ignoring those decisions of the Supreme Court and proposing to increase and actually increasing the grace period now for 18 months following the vote of no confidence. Now, the concern is here is there is already an 18-month in place following the election of the Prime Minister. And assuming Parliament is then convenes on the first instance in August of a year following election, 18 months then would follow. After 18 months, if there's another motion of no confidence, it will then trigger another 18 months and only leaving a small window of less than 12 months. So now that this bill has been passed, proposed law has been passed, any vote of no confidence that were to be moved that is unsuccessful from this period going on will trigger it at 18 months, will basically essentially carry the Prime Minister and his government to the next election, to 2027. Fortunately, we have enough case law and there's enough decisions by the Supreme Court concerning extension of grace periods So it's more than certain for those in opposition who are quite confident that the application, once heard and determined, that it will strike down this proposed law, sending the Prime Minister and the government back to the drawing board on the wrong side of history. And the Constitution will be continued to be upheld and protected by the Supreme Court and the rights of people. And now I note that the comments by the Minister for Justice by saying that this is to ensure political stability, this is to ensure that the government has its plans. There is absolutely no reason to change the law to run away from a vote of no confidence. If you have the numbers, you can hear a vote of confidence every single sitting and defeat it.
Like Samoa,
which is the practice around the globe. All democracies around the world, this is the practice. No one changes the law to run from a vote of no confidence. It's unheard of other than in PNG. So it's disappointing that the government chose to approve at the final reading in the way it did in yesterday's reading, but based on also the comments made by the opposition leader, he takes the initiative. The LLG of his province, district has already filed, and then now that it's no longer a proposed law, then the opposition now have the opportunity to also file a Section 18 and to also mount a further challenge against the proposed law. And based on precedents of previous sittings and hearings of application, we expect that decision process to be determined within 3 to 6 months. So before the end of this year's calendar. Thank you.
What I want to say is this, all public offices, all offices that we hold, whether it's parliament or in the bureaucracy or in the judiciary, these are public offices. So we have to execute our responsibilities in a very transparent way and remain accountable 24 hours a day. The duty to remain accountable stays with us as public office holders every hour, every day, every week, every month, every year. And that duty is continuous. If you look at the judiciary, very little restrictions on their duty to hold themselves accountable. The bureaucracy likewise, very little limitations, restrictions on their obligation to be accountable for their actions. But you come to the parliament, we're now beginning to shut down the doors. We have a 5-year term to serve. This amendment here effectively means that over a 5-year period, you have only 1 year, one opportunity to hold the government accountable over a period of 5 years. You have only 1 year, and within that, one shot at holding them accountable. And if you didn't, bad luck. They remain unaccountable. So what I see happening here, which is going to be very dangerous for our country, is this. Yesterday, they passed this amendment to narrow down the window of opportunity of the parliament to just one shot over a period of 5 years, and it's game over. You cannot challenge them to be accountable anymore for the rest of the period of 5 years. And they've covered all the valid points here, which I support. But then today, they did something else also that makes their government less accountable, less transparent. So 2 days in a row, they've done two things which makes the government less accountable, less transparent to the people of Papua New Guinea. And that is, today you note on the floor of Parliament, a bill was passed to amend the NEC Act. Did you notice that? Now there's a section in there, a very important section, which says that the final decision of the NEC is non-justiciable. The final decision of the NEC is non-justiciable. You go back and look at your draft copy of the bill, which is now law. So everything that the bureaucracy, the judiciary, even the parliament does revolves around the decision of the NEC. But if you cannot challenge an NEC decision, bring into evidence the decision of the NEC, how can you hold the NEC accountable? Do you see? They've just made, and it's just been slipped in with the rest of the bill. We couldn't debate it because maximum opportunity was not allowed. So it's been slipped through as part and parcel of the entire bill. And now you have an NEC whose decisions will never be subject to public scrutiny, criticism, challenge, and also justiciable in a court of law. Very dangerous. This government is becoming increasingly opaque, non-transparent, and also non-accountable. And dictatorial, you see. You can't even challenge the decisions of this government in a court of law now. But what about all the government decisions? How can we go back, like the judicial reviews on, take the appointment of departmental heads, for example. Every time some bad decision is made on nepotism or whatever, the candidates take the matter up in court on a judicial review, and they table a copy of the NEC decision as the basis upon which they challenge it. Now you can't do that. Whether it's going to be a contract or loan agreement or some major decision the NEC makes, you cannot table the decision in court and have it reviewed by an independent panel of judges. So it's getting very scary for me. Yesterday, they made the parliament less transparent. Now, today, they make the NEC less and less transparent. 2 actions in 2 days. The government has become immune, almost made themselves immune from accountability. That's very serious for all of us. So I want to wind up by saying this. These things are called pressure valves. Pressure valves. We hold this power in trust for the people. And for their benefit and based on their feelings, we come in and we go through these mechanisms to keep releasing the pressure as it mounts through a properly regulated process, such as the VONC. But if you look all the doors there, or narrow it down to just one shot, how will the people be able to ventilate their frustrations? And if the formal legal system doesn't give them space, of course, nothing stops them from taking the law into their hand on the street. And St. Julius, in one of his final speeches out there at the front of the parliament, he expressed his fears about that. We were there, we heard it. So it's a very sad day for us, and I'm happy with my colleagues here. We, on behalf of the people, we're going to take this issue of the VONC plus the Christian thing into the Supreme Court and ask for a reference. We file a reference, we ask for the Supreme Court to give an opinion about both those amendments. Yeah, it's a disappointing day. The government is no longer exercising wisdom in the way it makes its decision, and it's becoming, I think they're turning the government around. Now, I've been telling other people, this current government is more interested in looking after itself than the government. And then you just said, Governor Allan expressed the same sentiment. And a lot of people out there feeling the same thing. This government is turning inward, looking after itself more than it's interested in looking after the interests and affairs of the people of this country. So we'll see what comes about in the next few days and couple of weeks as we get our lawyers to work on this thing. So I support everything that our leaders have said.
Okay, just final comments before we take some of the questions. I think it's become blatantly obvious now after 6 years of this Marape government that he's plotting and scheming to just cling on to power by just manipulating Parliament, manipulating members of Parliament, and making these sort of flagrant amendments to constitutional provisions to just stay in power. That's the underlying reason behind all these changes. And now we heard the Honourable Kerenga also elucidate on these nefarious changes to the NEC bill that's going to make NEC untouchable. So how do we promote transparency and accountability in the country? Furthermore, it's important right now for the country to understand that there's enough intelligent Papua New Guineans. The wool can't be pulled over our eyes anymore. This deception and skullduggery has to just be exposed for what it is. Members of the Private Business Committee are all Pangu members. Now, recently you had the Deputy Speaker also join Pangu. You've got the Speaker, Pangu, Deputy Speaker, Pangu, and all other members. The Governor for Western Province, the Governor for Gulf Province, the Governor for Southern Highlands, the Governor for Ella Province, they're all Pangu. So how do you expect an objective decision to take place when we're pushing a vote of no confidence? So this is how we've had a Prime Minister just completely fixated and obsessed on staying in power, manipulate the whole system, now amend legislation willy-nilly at the detriment of the people of Papua New Guinea. So on behalf of the opposition, we won't allow this mockery of the Constitution to continue. In tribute to Sir Julius Chan, as one of the founding fathers and the person who participated in developing this Constitution, and that's how we continue to honor the legacy of the founding fathers, Sir Michael Somare. And if they had any sense, they would have consulted with Sir John Momis, like the Honourable Governor said, who's still alive. But this government doesn't have any sense. This government's not concerned about the people. So we will take it to court next week, and we expect to just nullify this amendment and preserve the Constitution. With that, thank you very much, ladies and gentlemen. If there's any questions, feel free. Thank you.